Good morning, and thank you for joining us today. We hope everyone managed to have a break over the long Easter weekend and is excited. That's an insight into our puns for the day to be back talking about our favourite subject, warranty and indemnity insurance. I am joined today by my colleagues Sophie Briggs and Harriet Strevens for the third in our series of warranty and indemnity talks. 2 points of housekeeping to start. You're very welcome to put any questions in the Q&A box. If we have time at the end, we will try to answer them. If not, we'll pick them up directly with you after the webinar. Second, the session is being recorded, but please don't worry about dressing up. While you can see us, we can't see you. So, if you're new to the series, please feel free to have a look back at our earlier talks, which go through the principles of the policies, some of the fantastic authority that came out during 2024, and some examples of the sorts of breaches we see on these deals, along with the sometimes surprising consequences. They're both available on our YouTube playlist, and we'll happily send you the link if you'd like to watch them. Just leave a comment in the Q&A box. If, however, you're a regular by now, you'll know we love piggybacking on a holiday to come up with some entirely unapologetic holiday-based puns and examples to try to make what could be a dry topic slightly more lighthearted and approachable. And we are doing that again today. While that means you may have to bear with us on the occasional Easter-related pun, it also means that if you stick around to the end of the talk, we have a couple of questions about the W&I market, which you can fill in, and whoever gets closest to the pin wins one final round of Easter chocolate. So, for the purpose of today's talk, we are going to look at the development of the synthetics, both synthetic warranties and synthetic scrapes, what they are, why people want them, and some of the drawbacks.
So as a very brief reminder for anyone that doesn't routinely deal with these sorts of claims, warranty and indemnity, or reps and warranty, policies are taken out to ensure the risk involved in the acquisition of a target company. Typically, a company is acquired by purchasing the existing shares from their owner, and that's done by way of a share purchase agreement or an SPA. It is also possible to simply buy the assets of a company, which attempts to leave behind its liabilities, in an asset purchase agreement or APA. Whilst W&I policies can assist with both scenarios, we are typically concerned with companies purchasing by way of an SPA. During the sale process, the vendor will typically make a number of representations about the company, what it does, what it is, who owns it, who it works for, and provided the risk is fairly explained to the underwriters and subject to certain restrictions within the wordings around, for instance, knowledge, they'll step into the shoes of the vendor after the acquisition has completed to ensure that the consequences of those representations or warranties being inaccurate. The warranties we most commonly see being breached centre around the accuracy of the company's accounts and its tax position, the failure to disclose material differences in the company's client book, and the assets of the company, by which we mean its building, its plant and machinery, that sort of thing.
Now, as we've said, in a standard W&I policy, the insurer steps into the shoes of the vendor. So to the extent that the insured would have a claim against the vendor under the SPA, it will now be able to recover those losses against the insurer. However, what happens where a vendor is either not able or not prepared to give those assurances? That's where the synthetics come into play. Today, we're going to talk about what they are, where you tend to see them, and where they can have some limitations. Now, before looking at how they fill that gap, it might be worth addressing the obvious question. Why would anyone be willing to insure a warranty which the vendor themselves wasn't willing to give? And it's a good question. The most frequent answer is they crop up in situations where you have a distressed sale. Typically, an insolvency practitioner selling off a company that's gone into liquidation or administration and either simply doesn't have the information to give the warranty sought or is not prepared to do so given that they take on a personal liability. The other situation in which we see vendors unprepared to agree warranties tends to be the sale of companies owned by PE houses, who either don't have close enough involvement in the target company or predominantly they want a clean exit, totally out with no potential comeback. So, in those situations, the purchaser can look to an insurer to bridge that gap with a synthetic warranty, warranties which, in essence, are entirely artificial in terms of the SPA. If, for instance, a liquidator selling a company had not been able to fully understand a company's order book, it might not be prepared to agree a standard onerous contract clause, which, in essence, is a clause which It requires the vendor to identify any contracts which impose a significant or disproportionate burden on the company, for instance, selling products as a loss leader. The purchaser, however, might not be prepared to acquire the company without that reassurance. That's where an insurer can step in. Rather than the liquidator giving an insurer can be prepared to write a synthetic warranty that the company has fully disclosed any unduly onerous contracts and the deal can proceed. You may be asking why an insurer would be prepared to do that in circumstances where the vendor would not. The most frequent answer we hear is they'll do so if they are able to satisfy themselves that the warranty they're signing up to is likely to be accurate. Now, we hear that the benefit in writing a warranty totally outside an SPA is that underwriters are able to take an increased level of due diligence on that particular aspect of the deal themselves, as opposed to relying on the vendor having properly undertaken their due diligence or relying on remedies around misrepresentation if they've not.
So let's try to bring this to life a little bit with a somewhat belated Easter scenario. So the Easter Bunny has decided he is ready to take life a little bit easier and he wants to scale up his production facility so that he's not having to source all of his eggs before Easter. He's therefore decided that he wants to buy Badbury's manufacturing plant. And we do need to give a disclaimer here that any similarity to a real chocolate manufacturer is completely accidental and this company is purely fictional. Badbury's, as you may be able to tell from the name, had a reputation for not being the best chocolate manufacturer in town. The Easter Bunny was conscious of his position with all the children around the holidays and he wanted to ensure that the quality was up to scratch. So he therefore wanted a quality assurance warranty to be included in the SPA. Badbury's assured him that their product was fine and that their private equity parent company would not let them agree a warranty. Now, fortunately for the Easter Bunny, his brokers had approached the Generous Underwriting Mutual, or GUM, to propose that they could satisfy themselves, presumably with site visits and their own sampling, that the chocolate was up to scratch. So as a result, GUM was asked to consider writing a synthetic warranty stating that the seller warrants the chocolate manufactured in the plant will conform to all British standard manufacturing specifications, including but not limited to consistency and melting temperature. The Easter Bunny had acquired the plant in December in the run-up to the holiday season chocolate rush. In the process, the very eager underwriters had been out to perform their own due diligence and site visits, and the produced and stored chocolate had tasted fine. They were therefore very happy to write the totally synthetic warranty. However, by the time Easter rolled around, and given that we are all experiencing global warming, the Easter Bunny found that the increase in temperature had resulted in all of the stored inventory melting, and he had no idea what to do. He had lost all of his stock. He remembered that Badbury's had said no to his quality assurance warranty, and he thought he was out of luck. Now, fortunately, his highly proactive broker remembered the synthetic warranty which GUM had agreed to write and lodged a claim for the cost of the production of all the chocolate that had been lost. GUM, complying with their TCF obligations, were happy to step in to make sure that the Easter Bunny had an interim payment to acquire his lost stock from third parties and settle his claim in time for Easter.
Wonderful, where insurers can come in to save the day. So, what about synthetic scrapes? What are they? Well, the picture is very similar. As a synthetic warranty adds a warranty that's not featured in an SPA, a synthetic scrape removes qualifiers which are required to trigger breaches of warranty in an SPA. In what is an increasingly soft W&I market, we're seeing a lot of policies synthetically removing SPA de minimis requirements. But for today's purpose, we're going to focus on the two most typical synthetic scrapes impacting SPA protections: knowledge and materiality. In a standard SPA, you'll see plenty of examples of warranties which are prefaced with a caveat along the lines of, to the best of the vendor's knowledge. While in some cases, it may be perfectly evident that a vendor had knowledge of a breach. The company may, for instance, have active proceedings in breach of a litigation warranty. There are, however, swathes of grey area where it's open to a vendor to say they had no knowledge of the breach. What if, for example, a claim had been issued but not yet served? What if a letter of claim had been sent to a branch of the company, but not yet brought to the attention of any of the members of the senior management who constitute the knowledge of the company? As you can see, in those situations, it's often to a buyer's advantage that the knowledge caveats are removed, so they have certainty over whether there's an actionable breach. It would not, for instance, matter whether the letter of claim had made it to the attention of a senior management, just that it had been received. Similarly, you will often see in SPAs that there are warranties that the target company is not party to any material issues, which could be they're not party to any material litigation, they're not they've not had any material changes to their client list or their order book. Materiality scrapes do precisely what they suggest, and they remove the requirement that any breach must be material. Those scrapes are typically attractive to buyers. They remove the need to agree that which is material. Is, for instance, the loss of a single client material if the company expected a separate prospect to replace that client pre-acquisition? Is litigation for, say, breach of IP rights material if the company believes that the relevant intellectual property is not central to its business? Similarly, and just to keep life interesting, we see what are called double scrapes. Double scrapes are where you first remove the materiality or knowledge qualifiers, and then separately, you remove the indemnification basis qualifiers. Now, we often slightly lazily say that we can use the terms insurers use to describe their transactional liability policies interchangeably. Some will say warranty and indemnity. Some, more often US focused, will have reps and warranties. Some will have transactional risk or transactional liability. However, there is a real difference because going back to day one of contract law, there are material differences in the consequences of breaches of warranties, breaches of indemnities, and whether or not something is a breach of representation. Now, we have plenty of case law that helps to illustrate the impact of a breach of warranty. The buyers to be put back in the position they would have been had the warranty been true. There are some nuances around that calculation, but typically it's done by calculating the diminution in value of the company with the inaccurate warranty or what the person would have done. That calculation, however, brings with it issues such as remoteness, as well as proportionality, necessity of cost in some instances, and those issues are largely removed if we look at a breach of an indemnity.
So, going back to our so far lucky Easter Bunny. Given Badbury's reputation, the Easter Bunny required a warranty setting out that Badbury's was not subject to any ongoing or threatened litigation. Badbury's lawyers were prepared to agree to the deal, but only on the basis that the warranty would read, as it says on the slide, the vendor warrants, to the best of its knowledge, that there is no outstanding, pending, or threatened material litigation against the company, and an issue is known for the purposes of this warranty if a member of the senior management team has actual knowledge. Shockingly, post-completion, it transpired that its major competitor, Bestley, had already sent a letter of claim to Badbury's claiming that it had infringed its intellectual property rights by stealing the recipe to its market-leading Bestley dark chocolate bar. The Easter Bunny was understandably hopping mad when he found out. He wanted to bring a claim against Badbury's under his SPA for the breach of warranty for failing to disclose the litigation from Bestley. By this stage, we're sure you won't be surprised to hear that Badbury's did not accept the Easter Bunny had a claim under the SPA. They said that they had 3 unassailable defences to any claim. First, they said that the litigation could not be material as Badbury's dark chocolate only comprised 5% of their overall sales, and apparently dark chocolate is healthy and that ruins the marketing appeal. Second, the letter of claim from Bestley had only reached an intern in their marketing team before the acquisition. The intern had not passed it on to their manager and had certainly not passed it to central management or any of Badbury's senior managers. Third, they did not accept the letter of claim was sufficient to trigger the warranty that there was litigation. It was merely an expression of discontent. Now that spelled trouble for the Easter Bunny. While material may well be subjective, the Easter Bunny was in the food production business and was acutely aware of the decision in Finsbury, which suggested that a material contract had to relate to at least 10% of the company's profits. Now, any sensible W&I insured would, as any insensible W&I insured would, the Easter Bunny went straight to the broker, who, as it transpired, had managed to do an excellent, pardon the pun, job for him when he placed his policy. He was concerned that litigation warranty may not be sufficiently robust and had managed to agree with the generous underwriting mutual, again GUM, that they would write a synthetic materiality scrape into the W&I wording. The synthetic scrape amends the term of the SPA insofar as the Easter Bunny's claim under the policy against GUM. That synthetic scrape amended the policy to discount the materiality qualifiers throughout the SPA. So as a result, whilst the Easter Bunny couldn't go after Badbury's, the materiality issue would not impact on Gum's indemnity. But what about the knowledge qualifiers? Badbury's had specifically worded the warranty so that there had to be knowledge among the senior management of any litigation. Now, it turns out his broker had cracked that problem as well. Along with agreeing a synthetic scrape for materiality, his broker had managed to convince Gum to agree a synthetic scrape in relation to knowledge. So that scrape amended the scope of the insurance to delete the "to the best of our knowledge" caveat wherever it occurred throughout the SPA. So the Easter Bunny was home and dry, almost. As he recently found out, the dark chocolate only amounted for 5% of their production run, and for ease, we're going to say that it made up 5% of their profit. The Easter Bunny had admittedly been desperate to buy Badbury's so that he could enjoy his golden years before going out to pasture. He was looking at potentially expensive litigation with Bestley, but he didn't want to give up on producing dark chocolate for the health-conscious kids at Easter. He was worried that he would not be able to show that a 5% hit to his production run would have caused him to change the terms of his acquisition of the company. So what could he do? Gum were insistent that it was a breach of warranty and he would have to show the diminution in value of the company. Unfortunately for Gum, it turns out that the broker had been on top of that possibility as well. It had managed to convince Gum to write the policy with a synthetic indemnity basis, which treated any breach of warranty as a breach of indemnity. As a result, the Easter Bunny was entitled to cover the costs of instructing an expensive law firm to defend the matter and agreeing a settlement which allowed him to continue to produce the dark chocolate eggs for the health lovers under license from Bestley. Happy bunnies all around.
So where does that leave us? Now, while our Easter special case study could be slightly contrived, it does start to highlight the areas where insurers can really step in to provide the cover that acquiring companies require to give themselves the comfort that they have a source of recourse where the vendors either won't or can't agree to give the requisite warranties. For insurers, provided they can reassure themselves that they're able to do their own due diligence to the extent they have comfort that the warranties are not likely to be breached, and they're no longer reliant on the insured's due diligence, and that they can rate the risk appropriately, it offers a very flexible platform in an already highly bespoke product to serve their target market. Now, before you all go and enjoy your coffee, as we said at the start, it wouldn't be Easter without chocolate. And while I may now be on my 5th health kick of the year, it wouldn't be right not to give out some chocolate on an Easter-themed webinar. As soon as we sign off, you'll be presented with a feedback form, and I'm reliably informed it has 3 very easy chances to win yourself some chocolate. Whoever gets closest to the pin with each answer will win themselves a delivery of chocolate goodies. Just fill in your best guess and your contact details, and we'll be in touch. If you don't want to have a shot at the questions, we'd still love to know what you think, both on this topic and anything you'd love us to talk about in future cover talks. We are also going to circulate the first of our warranty and indemnity tea break newsletters over the summer. It's a 10-minute read of W&I issues, updates, and news to read over a morning tea break. If you would like us to include you in the circulation list, please just let us know in the feedback form. Finally, we would love you to join us for our next cover talk on the 26th of June, when our colleagues Tom Grant and Andrew Spence will be looking at the contrasting approaches taken by the Ombudsman and the courts in coverage decisions. Sounds wonderful. Thank you again for your time. Have a great day.